All right, this is working, wonderful, and I see my slides are up. Okay, thank you very much, first of all, to the organizers for the invitation. I feel it's a true honor to be able to present today some of the work I've been doing on the regulation of AI as a policymaker, as a legal practitioner in a law firm, and also as an academic, which is the role I'm keeping now. I've been coming to this conference for a few years, and if I would have been offered a keynote last year, I would have been able to talk about a very clear logical path, namely that AI regulation has become more and more important over the years. We have moved since 2018, when, for instance, in the European Union, you had a high-level expert group on AI that drafted ethics guidelines for AI, a move from soft law, guidelines, all kinds of non-binding draft versions to guide people towards responsible AI. We've been starting to move slowly towards binding laws. That would have been my story, and my prediction would have been that as the years would pass by, more and more countries and regions would adopt binding legislation on AI. A year ago, not only the AI Act was almost adopted, but also in Brazil, there was legislation of AI on the table. The situation is different today. And in many other countries, we can say that the situation is very different today. And one of the reasons for that is the regime change in the United States, and the fact that in many countries, the voices that were already skeptical to have AI regulation in the first place are feeling bolstered, because the narrative is now stronger than ever that regulation hampers innovation and just stands in the way, so we should stay far away from it. But also elsewhere, we just see that even in the European Union, where the AI Act has been adopted, there are voices that say maybe we should tune it down a little bit, because it might stand in the way of AI dominance, as the previous keynote speaker mentioned yesterday. So if the European AI Act would have been on the table today, I'm not sure it would have passed. But it's extremely important to talk about AI regulation, and that's what I want to devote this session to. Nevertheless, hoping that at some point the tide will turn, and the voices that are now dominating the field and maybe preventing regulation from coming about will see differently in the future. So this is what I want to talk about in the next 42 minutes that I have left. I want to talk a little bit about the importance of law as a governance or regulation method. Law is a little bit different than other governance methods. And I know there are not that many lawyers in the room, so I'm curious, by raise of hand, how many lawyers do we have in the room? Okay, it's a clear minority, but they're still there. That's good to know. I'll then talk a little bit about objections to the regulation of AI. Because as a lawyer, I'm confronted with those objections frequently. Mostly by tech companies, but also by other people who just don't see what the law has to do with AI. We'll then talk a little bit about the challenges of regulating AI, why it's tricky, what kind of choices regulators have to make. And then I'll focus a little bit on the European AI Act as a case study, just because it's the most comprehensive regulation that's out there today, but also because it's the one that I'm most familiar with, and we'll draw some lessons from it, and then conclude with the road ahead. So let me start with the rule of law. The rule of law is a difficult concept. Even for lawyers, it's a difficult concept. But in essence, what I want to focus on is, why is law special? What do we actually mean when we talk about legislating AI and not just regulating it? Because regulation is a broader word than legislation. And for the non-lawyers here, I thought maybe it's useful to just mention that. You can regulate, namely modify people's behavior in different ways. We are being regulated all the time by many different forces, and law is one of them. Law is a very explicit mode of modifying or regulating people's behavior. But think, for instance, of the market. The market is also a regulatory modality. The market regulates our behavior, and we can also regulate the market in one way or another. Social norms also regulate and guide our behavior. Right? Think of ethics guidelines or more general ethical and social norms. There is no law against me destroying this whole room, but it's not very ethical. Architecture, very important, also a regulatory modality. And this is something that for AI engineers or practitioners is very important to keep in mind. An example was given, you might be familiar with it, with bridges, right? A very low-tech application. But you might be familiar with it. So a couple of decades ago in Long Island, the architect Robert Moses built low-hanging bridges that made a bridge between inwards Long Island and the seaside. And why did he design them low-hangingly? We never know how intentional it was. But if you build bridges in a very low-hanging way, only cars can go through it, not buses. Who takes the car in Long Island, especially a few decades ago? Only higher income white families. Who took the bus to the seaside? Usually black families of people of lower income. And so having a bridge designed in a low manner was effectively a way of regulating who has access to the beach and who doesn't. So this is just an example of how design or architecture is also a regulatory form. So there are different modalities of regulation, and I want to focus on law. And I want to focus on why it's a special form of regulation. And this is where the concept of the rule of law comes in. You might have heard of it. It's a core value in liberal democracies, but in nations more generally. And effectively, the core idea behind it is that everyone is bound by the law. Also those who adopt the law, also those who implement the law, they're also bound by the law. And the law has some goals that protect us. The law is a protective means. It constrains political power, right? Because if politicians want to adopt laws, they need to follow the existing laws already. They can't just do whatever they want. They can't just change their mind from one day to the next. They have to follow the rules as well. This is also why the rule of law is often contrasted with the rule of men, right? And it could be the rule of people more generally. But basically, the idea is that we want to be governed by rational norms that have been put down somewhere, that we all agreed upon, rather than the whims of men that can change their mind over time. If we just think about the AI context, we want to be governed by laws that we all abide by, rather than by the whims of tech bros, right, who decide one day to the next how they want to switch about the technology and through the design regulate us. It also enhances formal equality because, as I mentioned, everyone is bound by the law, right? And everyone is bound by the law in an equal manner. No one is above the law. That's the core idea of the law. There are some core requirements that a law should meet in order to abide by the rule of law. Laws should be made public. They should be accessible. They should be general. They should be written in a clear language that we all understand it. It should be prospective, consistent. So these are all qualities that laws should have. And then finally, because of these qualities, we are able to predict the consequences of our behavior. If I steal your backpack, for instance, I know that I will likely end up in jail or have to pay a big fine, right? I can predict the consequences of my actions. I can plan my life because I know what the law is, and I know that it won't change overnight without prior notice, right? And that kind of predictability gives us as well agency and human dignity to plan our lives. So all this to say that the law plays an incredibly important role in our lives, and it's not always a role that we think about. Now, I have to have a slide here about the limits of the law, because I don't want people to think, oh, she's a lawyer, of course she loves the law. There are limits to the law, right? First of all, you can't regulate everything, right? The law is not a solution for every single problem. There are some things, I mean, I can adopt a law, or I can help people to adopt a law tomorrow saying that war is illegal. It's probably not going to stop wars, unfortunately, right? So there are some things that the law is just powerless against. Moreover, if you're going to adopt laws, there is always a risk of regulatory capture. Regulatory capture means that the entities that you're trying to regulate, let's say AI companies, might capture the regulator and make it so that the regulator no longer acts in the public interest, but in the interest of the companies it's supposed to regulate. Think about lobby groups, right? It's their job to try to capture the regulator in a way so that their interests are protected by the law and not the public interests which the law is supposed to protect. Laws can also be abused, right? They can be abused by regulated entities. Think again of a company. I think in yesterday's keynote, the example was given of a company that follows the rules to the letter, but in a way that actually subverts the very purpose of the law, right? But there's another potential abuse. Governments can abuse the law as well. They can adopt oppressive laws, right? The law can be a very powerful tool to actually eliminate the protection that it's supposed to give us. And the thing is that legislation still gives you this veil of legitimacy, because if it happens by law, it's supposed to be good, it's supposed to be in the public interest, right? An example can be the laws that were adopted in Nazi Germany, the Second World War. These were laws, they were adopted by parliament, but they were not in the public interest. They were not in compliance with human rights as we would see today. One of the things that I've been working on is a book called Algorithmic Rule by Law, which Talia mentioned, talks about this. This is not rule of law, this is rule by law. This is using the law as a tool to actually undermine the protection it's supposed to give. And a recent example of how laws can be used to erode protection is what we're seeing in the United States. And I'm sure there might be other examples. How are they trying to limit states' power to adopt laws? They're using the law as a tool to do that. It's by sneaking in a provision in a law that they're trying to prevent states in the years to come to adopt protective legislation. So yes, the law is not perfect, it has limits. But in a liberal democracy, it plays an incredibly important function. When we adopt a law, it's an expression of our values, of our interests, that we come about through public deliberation. And it takes a while, this public deliberation, because we live in a plurality of opinions in a democratic society, right? It's not just one opinion that dominates everyone. And digital sovereignty is sometimes used, in the context of becoming technologically independent and caring a lot about your own technological interests. But actually, normatively, this is also what digital technology is about. You want to be sovereign by deciding by law your own digital destiny. You want to decide sovereignly what kind of impact technology, and especially technology designers, have on your society. That's something you can do with law. And this is also where friction plays an important role. And engineers typically are trained to try to eliminate friction as much as possible. You want things to go as smooth as possible. But in the law, especially in a liberal democracy, you want friction. Because it takes time to have a public debate if you have a plurality of opinions. Again, if it's just a dictator, it can go very fast. You can have a law adopted in 2 seconds. But that's not what the law is about. You need friction. The law also protects human rights and democracy. It's always contestable in a liberal democracy. And it's part of a system of checks and balances, right? If the government adopts a law that violates a higher norm, for instance, the Constitution, you have judges, a judiciary that can hold the government to account. Parliament holds government to account. So you have a system of checks and balances, and all of that is part of the legal system and the power of the law. So I hope I convinced you of what an important role the law plays. And it's a role that is in our hand because it's, by definition, a very democratic tool in a liberal democracy. Now, taking all this to the AI context, right, into AI legislation, I'm going to talk about 3 common objections that I frequently hear when I make the suggestion that we should use this powerful democratic tool to decide what our AI destiny will look like, what kind of applications we want to have in society, and especially under which conditions we want to have them. So the first objection I frequently hear is, regulators don't know anything about AI or the technology, so how on earth will they regulate it, right? And it's probably a valid point in the sense that in most parliaments around the world, I doubt that there are many data scientists or engineers, right? Most parliamentarians don't know that much about AI. That's a valid point as such. But it's not a valid point to then conclude that we cannot have AI regulation. There are many laws out there that require some sort of specific knowledge, but they were adopted without a problem. Or at least they were adopted. It's not easy, there is friction, but they got there. Think about food safety legislation. How many experts in parliament are food safety experts? Think about aviation rules. Think about pharmaceutical regulation. How many parliamentarians around the world are experts in pharmaceuticals? But still, we are regulating these products. There are specific rules on liability, on requirements that you need to abide by, on testing and experimentation. So it's not a good enough reason to say that for AI it's completely different, and you need to be an AI expert to know what the rules for AI should be. Plus, parliamentarians can also invite experts in hearings. In almost every parliament in the world that I know, this is an existing procedure. You invite experts, and ideally stakeholders from different diversity of opinions to the parliament, and they discuss the pros and cons. And then the parliament, those that we democratically elected, make an informed decision. Second objection. Technology evolves so fast. AI evolves so fast. There's no way you can possibly adopt legislation that actually can catch it because the law always runs behind. I think the first part is true. Technology does evolve very fast. But that doesn't mean you cannot regulate it, or it doesn't mean that the law always necessarily falls behind. First of all, as the example I always make, you have in Belgium today, and in many other countries in the world, especially in civil law, still rules that are almost identical to the rules that were adopted in the Roman time. So don't tell me that laws necessarily always run behind, right? These still apply today. Secondly, it all depends how you adopt legislation, how you formulate it. There are ways of going about it. There are ways of having, for instance, a broad formulation that has an adaptable interpretation over time. To give an example of the US, nowhere in the US Constitution is there written that there is a right to privacy. However, there exists a right to privacy in the US today. And I'm sure that in many other jurisdictions, wherever you're from, there are similar interpretations. There are similar things. So you can interpret the law in a way that evolves with its time. That's actually a strength of the law. And then the third, probably the one you're most familiar with, and the one I hear most, law stands in the way of innovation. Law harms innovation. So we cannot have law because we really want innovation. To those people, I usually say, well, first of all, what's the purpose of innovation? Why do we want innovation? We're not looking for innovation just because we want innovation as such. It's not an intrinsic good. We want innovation because we believe that it can enhance individual and societal welfare. It's because of many innovative things that we today have wonderful healthcare if you compare it with 100 years ago. But we want innovation because it adds, it's a positive, it's a benefit to society. And it's true that it's difficult to know in advance how much is going to benefit society, so you need some leeway there. But not every single type of innovation is necessarily beneficial to society. Controversial example, perhaps, but the atomic bomb. To which extent is that an innovation that we absolutely needed to have in order to have a better society, right? And in many countries, human cloning, for instance, has been prohibited. It could be a potentially interesting innovation. It's an innovation, but that doesn't mean that it's necessarily in line with the values of society. So the law doesn't hamper innovation as such. If it's designed well, what the law is supposed to do is to guide innovation. It's to say, this is a type of innovation that aligns with our values. These are the values we have. These are the things that are not compliant with those values. So if you design things that are not compliant with it, we don't want that. So innovate as much as you want, but do it in a way that complies with those values. That's what the law is supposed to do. It's supposed to guide innovation. And in fact, if you want to boost AI innovation, you're going to need the law, most likely. Let's say a government wants to subsidize AI companies. If you want to grant subsidies, you need to do it through a law, most likely. Or think of another example. You could very well devise a law as a government that wants to attract more AI talent, a law that facilitates the immigration of AI engineers, right? Makes it easier for them to immigrate to the country. That's something you need to do by law. Law is not only constraining, it's also enabling. It depends how you use it. It depends on the purpose. But that means that it's fundamentally wrong to say that law always hampers innovation. A law well designed can boost innovation. And most importantly, it can boost the kind of innovation that is compatible with the values of a society. Okay, so we can put the objections aside. There might be others, but we can put those aside. I want to talk a little bit about challenges. Because it's not because we can think that actually adopting regulation of AI is a good idea, that it's also easy to do so. There are still regulators out there that actually do think about regulating AI. And they are faced with difficult challenges, difficult choices that they need to make. Because it's not because it's possible to regulate AI and because it's a good idea that it's also easy to do so. So let me walk you through some of the challenges that when I was still working for the European Commission, for instance, and we first were going to design the AI Act, I was faced with. Right? It's always easier to complain about a regulation if you're in academia than if you actually need to write the damn thing yourself. Okay, what are some of the regulatory challenges? First of all, you're going to have to think, if we want to regulate AI, how do we go about it? What is the target of the regulation? Am I going to regulate AI systems, AI models? Am I going to regulate the design process of the systems? Am I going to regulate the output of the system? Am I going to regulate the people that design the system or the people that deploy the system? It's a choice you're going to have to make. And I don't think there are necessarily right or wrong answers there. There are different pros and cons for whichever approach you're going to take. How are you going to define AI? If you want to regulate it, you're going to have to define it. And there are different options there too. You can go for a very broad definition. Right? You can talk about a machine-based system that infers based on data, that generates different kinds of outputs, that has some level of autonomy. The advantage of such a broad definition is that if another type of system comes along later, let's say generative AI, it could still fit in there because it's broad enough. So it's more future-proof. The downside is that the broader your definition, the more vague it's going to be, the less legal certainty those who are being regulated are going to have. They might say, well, am I falling under the definition or not? Whereas you can also make an exhaustive list. You're going to say, these are the things that I'm going to regulate, and if you're not on the list, you're not regulated. It's a bit more simple, straightforward approach. The downside there is, of course, that the list is always limitative, can be under-inclusive. There might be things that are not on your list, and then, let's say the next day a new big innovation comes along, you're not regulating it. And it's difficult to start from scratch, your legislation. And this counts not only for definitions, but also for categories of systems that you want to regulate. I'll talk a little bit more about the AI Act in a minute, but let's say you want to have a category of systems that you consider as high risk, right? And if you're high risk, you're going to be regulated. There are different ways of going about it. You can say, all AI systems that pose a risk to human rights are high-risk AI systems. That's one approach. The good thing about that approach is if tomorrow there's a completely new application that poses risks to human rights, it's regulated. It falls under the regulation. But again, the downside is that you can speculate, but does it really violate human rights? Mine doesn't, so I don't fall under it. Yeah, it's a bit more flexible in both directions. On the other hand, you can have a list that really says, these are high-risk applications. AI systems used in education, AI systems used by the police, AI systems used in migration. And you have a very specific list, and if you don't fall under the list, you're off the hook. It's easier, it's clearer for those that are regulated, but it's less flexible, right? Because if tomorrow you find out there's another application that is not on the list, what are you going to do? Another example of a choice that needs to be made. Let's say you want to impose obligations on AI developers or people that use AI. How are you going to express those obligations? And this is a little bit of legal jargon there, but there's a difference between rules and standards. Sometimes it's called rules and principles. I'll give you an example of a rule. A rule is that you say that every system that is listed as high risk needs to undergo a fundamental rights impact assessment. You need to assess, before you can use the system, what the impact on human rights are, and you need to put it in a pretty little document and be able to provide it to the authorities. It's clearly stating what you have to do. And if you do that, you comply. But you could also think of a standard, whereby you say, if you want to use a high-risk system, you need to take all reasonable efforts to minimize the negative impact on human rights. Yeah, that's an example of a standard. You're leaving it more open what kind of measures need to be taken. Advantage of the rule, it's quite clear what you need to do. You just do it and you're off the hook, you're compliant. Disadvantage, what if it's not enough? Because you can make a very pretty little human rights impact assessment document, but still infringe human rights, right? The advantage of the second is, the onus is on you to take all reasonable measures to mitigate the negative impact. Disadvantage, what do we mean with reasonable measures, right? So there are different choices there, and there are pros and cons for each. If you're going to intervene, are you going to intervene ex ante or ex post? Ex ante means you're going to impose obligations on AI providers before they put their system on the market. Yeah, so you cannot put your system on the market before you went over the requirements. Ex post is that you're free to do whatever you want as a provider, but if there is harm afterwards, someone can go sue you and claim damages, right? The downside is, by then the damage has been done. And sometimes damage is irreparable. So if the risk is very high, you don't want to wait until there is big damage. Then it's better to go ex ante. But ex ante is a bit heavier. It's a higher burden on those who develop the technology. So pros and cons. Which kind of enforcement mechanism? Are you going to let companies self-assess whether they comply with the legislation? Or should they go through a licensing scheme? Are you going to regulate horizontally or sectorally? And how do you ensure the future adaptability of the legislation? Right? How do you make sure that if new developments come along that you have not predicted in your list, for instance, that you can still change the list over time? Okay, so a lot of choices. And it also means that you have regulators or voices that say, it's too difficult to regulate AI, so let's just stay out of it. We're just not going to do this. To those people, I want to say this. Not choosing is also choosing, right? You're simply choosing to keep the status quo. And if that status quo is bad and doesn't offer much protection, you're choosing not to offer a lot of protection. Yeah? So you can't get off the hook by just saying, I'm not going to go into these hard choices. That's a choice not to do that. Okay. Let's move to the European Union's AI Act, right? So the European Union is a regulator, that was faced with all these choices. You know? And it was a long process to get there. Lots of friction, lots of debate, which is what we like, right? We don't want to have an AI law adopted overnight. That's probably not going to be a good law anyway. So let's see what kind of choices they made. So if you're interested about the process, I just wrote an article about this with Karen Young. But it was a long process that started in 2018 when we had the high-level expert group on AI that first issued guidelines on AI. Then those guidelines, with lots of public consultations and stakeholder input, were converted into a draft legislation, the AI Act. Then that was subjected to way more debate, public consultations, parliament, council. Interesting, long, but the result, right? We want the results. So what was the regulatory target? The AI Act regulates both the design process of AI systems, but also it regulates the people behind the system. It imposes some set of responsibilities on them. It takes a horizontal approach, meaning that you don't have separate pieces of legislation for different sectors, right? There's not one AI Act for education and one AI Act for medicine and one AI Act for the police. It's just one piece of legislation that regulates AI across different sectors, across government and across private sector as well. The definition of AI that was used in the AI Act is relatively open. So even though originally they thought about, oh, should we make a little list of what kind of techniques we are trying to regulate, machine learning, statistics, they said no, that's going to take us too far because there will be new techniques tomorrow and then we're outdated too fast. Let's go for a broad definition. Now, it's not because you fall under the broad definition in the AI Act that you're also regulated by the AI Act. Because what the AI Act does, it's creating categories of systems, and only if you fall within one of the categories of that system, there are new requirements for your system. It's called a risk-based approach because the categories reflect the level of risk of the system. And this is like one overview slide which tries to capture the whole AI Act. These are the categories that the AI Act establishes. You have a list of prohibited practices like social scoring, subliminal manipulation. If you fall under that list, it's prohibited. You cannot use that system. Then you have a category of systems that are considered to be high risk. And they're high risk because they pose a high risk for health, safety, or human rights. And that's also a list. There is a list of systems that falls under this category. For instance, systems used in recruitment, systems used by border control, by the police. Not all systems used by the police, but there's a pretty little list there that explains to you which type of systems fall under high risk. If you're in that category, you need to abide by certain requirements if you want to make use of that system. Then you have the category of general purpose AI models, which is a category that did not exist when the AI Act was first drafted. So they added it quickly once they realized it was a thing. This shows again the difficulty for regulators, right? Suddenly there was this ChatGPT that everyone started to use, so they quickly introduced more information on it and specific rules. But they could have also gone another way, right? They could have just said, general purpose AI, it's also a type of AI system. We just call it high risk, and then it's regulated under a broader definition. So here you see, if you work with a list, you need to be very specific. But if you would have opted for something more broad, you could have avoided the fact that a new thing was coming along and it wasn't in your regulation. Then you have a category of systems that seem to pose a limited risk, or at least they need more transparency, deepfakes or chatbots. You need to know that you're interacting with a chatbot. So they're also permitted, but they need to be more transparent. And then you have, according to the European Union, the bulk of the systems, the majority of AI systems that pose a minimal risk and they're not regulated. So if you're not in one of the 4 categories, there's no new regulatory requirements for you. Okay. What they try to do is that most of the lists that I talked about, they put it in an annex rather than in the core text of the legislation. And the reason why they did that is because it's easier to amend an annex than to amend the core text. So annexes can be changed almost every year according to a procedure foreseen. So let's say that next year there's another high-risk system that was not in your list, you can add it next year. So this was their way of trying to make sure that the law is still flexible. But the core text cannot be changed. And the prohibitions, for instance, are in the core text, not in the annex. So they cannot be changed. The obligations are a mix of rules and standards, right? So there is a little bit of both. And they're imposed ex ante, meaning that you need to comply with them before you put your system on the market. But no one is going to check whether you comply with them before you start using it. You do your own check, you can start using it, and only if someone complains later or there was damage, will it be enforced, and will someone check, did you actually truly comply with it? The enforcement is a type of enforcement called enforced self-regulation. This means that essentially, if you're an AI developer or deployer, you do a self-assessment. You check yourself whether you comply with the requirements. You check in which category you are, and you check which requirements apply to the category and whether you adopted them properly. And again, only if later it turns out that you actually didn't do what you had to do and there was damage, then can a regulator go after you, or can someone go to court and sue you? The reason why they did that is because they thought there are no public resources to let every single high-risk AI system provider go through a public agency who tests their product before it's on the market, like is the case with pharmaceuticals, for instance. Right? For pharmaceuticals, you first need to get approval from the government before you can put it on the market. For AI systems, they did not want to do that. Also because they wanted to ensure that it's still easy to produce those systems, right? Because there is already a cost in terms of innovation. That was a trade-off. And the way they want to help people to self-evaluate whether they comply with the AI Act is by letting them adopt standards. So if you abide by a certain standard, you have a presumption of conformity with the AI Act. There are also codes of practices that are being developed, particularly for general purpose AI. And there are templates that they're trying to develop to make certain things easier. For instance, for a fundamental rights impact assessment, which is an obligation that rests especially on public authorities that want to use high-risk AI, they're going to try to create a nice template which they need to fill in, and then they know, okay, I comply with it if I fill in the template. So all of these things they try to do to make it a bit easier to comply with a complicated piece of legislation. Now, if we evaluate it, I first need to say a word of caution. The article I mentioned earlier and many other articles they are quite critical about the AI Act. But again, as I said, it's way easier to criticize a piece of legislation than to write it. And I'm also aware of the fact that when you utter critique, it can also be used against you, in the sense that voices that are against AI regulation could say, well, look, there's so many mistakes, so many errors, so many flaws with the AI Act. So why even bother regulating it in the first place? You can't get it right. That's not the message I want to give today, okay? Sure, there are things there that could be better, but I still think that regulation can be very important and useful. Yeah? And that having the AI Act is better than not having the AI Act. So one thing to criticize, for instance, is that AI in the AI Act is treated as a product that needs to be made safe. And you just kind of have technical safety requirements that are supposed to be metrics for human rights. But human rights are not convertible easily to metrics and to technical standards, which is something that most of you know, right? Even the right to non-discrimination is not something that you can easily convert to something measurable and technical. And the AI Act points out high risks, but then, as I said, it lets you self-assess whether you comply with these requirements. So police can self-assess whether their polygraph system that tries to see whether you're lying or not based on AI, which is a little bit unscientific, is compliant with the AI Act or not, and no one stops them from using it. The categories, as I mentioned, they're all lists of systems that fall under it. They're under-inclusive. Yeah, there's systems there that pose a significant risk that are not in the listed category. And some of them you can amend, but it's going to be difficult to get agreement. And some of them you can't amend, like the prohibitions. Yes, some people need to carry out a fundamental rights impact assessment, but because they're so afraid of hampering innovation, they're thinking of finding ways to automate the fundamental rights impact assessment, which kind of goes beyond the idea of reflecting on how, your system can impact fundamental rights. But there are also positives, right? There's also something on AI literacy, which acknowledges the fact that it's not just about regulating everything. Experts should be involved. And there's a right to explanation when a high-risk system is used, and a right to file a complaint. So what are the lessons we can now draw? First of all, you can regulate AI. Yeah? There's a way of doing it. It won't be perfect. Yeah? There will always be scope for criticism. But one thing that they told me when I was still in policy making is that if everyone criticizes it, you probably did something right. Right? Because if only one party criticizes it, you might have tilted the balance too much to one side rather than another. But if everyone critiques it, you probably hit the sweet spot. And there are regulatory techniques out there that can ensure some regulatory flexibility, even with the evolving technology. Right? First of all, legal text. If you formulate it in a proper, broad manner, it can accommodate many future innovations. You just interpret it in that way. The AI Act does foresee future amendments by putting things in annex. It makes it a bit easier to adapt the lists that I talked about. And you can also delegate the specificities of the rules to other groups, right? To experts or to an agency. So there are ways to go about it. And the big advantage is we now have a law. It falls under the rule of law. It's now part of a system of checks and balances. And if the law is infringed, or if the government infringes the law, you can go to court and hold them to account. So let me close with a few words about the road ahead. I don't think it's a surprise if I say that it doesn't look very pink, right? Very rosy. One of the things I think we urgently need is international rules for AI, right? The risks of AI don't stop at the border, but it doesn't seem very likely. International cooperation is not really on the radar of most governments today. But I want to talk about two visions. I'm not talking about the vision of innovation versus regulation. And I'm also not talking about the vision of left versus right, all of which play an important role in the AI regulation debate. I want to talk about the vision of simple versus hard. Having AI legislation, having any legislation, having international cooperation, it's hard. And we like simple things. One of the reasons that ChatGPT is so successful is that we're kind of lazy. Yeah. We like to have one nice paragraph that explains us something that we can copy-paste, and that's it. Instead of looking through all these sources ourselves and having to think, so annoying. And unfortunately, there are many governments out there, especially populist and more authoritarian governments, that are playing into that feeling. They like to portray things as simple, whereas in reality, things are very hard. Things are complex, things are nuanced, because human beings are complex. Almost nothing that matters in the world is very simple and straightforward. So we're up against this problem. Because as I said, especially in a liberal democracy where you have a plurality of views, coming to legislation is hard. You need time. You need to speak with one another, people with different points of views across the political spectrum. You need expertise. You also need humility. You need to know that there are many things you don't know. You need to reflect. You need friction, which is part of a democratic debate. You need nuance. You need courage. And all of these things are hard. And we're too much attuned, or we're being attuned by populists to go for simple. And the most important thing you need in order to have good legislation is these three things. You need healthy democratic institutions. You need human rights protection, and you need respect for the rule of law. If you don't have those three core values, any type of legislation will be problematic, or there will be none at all. So I'll just close by inviting all of you not only to think about what all of us can do, each of us in our own modest way, to bring a goal of better AI regulation closer, but also to bring these three things that are incredibly fragile and under threat in all countries, including in liberal democracies, to protect this better. Thank you very much.